Okay, and Katrina Davis, this one is interesting. It says plea in parenthesis, but then I've heard that she has changed her mind. Is that maybe correct? Does anybody? That's you? Yes, ma'am.
Yes, we're still working on this term. They weren't correct according to our email
The terms of what?
of the deferred adjudication.
Every approach,
Yeah, I don't understand. Y'all come on up, please. Yeah,
the term she's referring to, I did check my email. I did agree that there would not be a fine.
there were why? There were.
I'm gonna waive a fine, Judge. The offer was it's 10 years deferred adjudication and waiving the fine.
It was 2 to 10.
Then you get to speak. Go ahead. Go ahead.
I explained to Ms. Davis that the court determines the term of probation, that it is anywhere from 2 to 10 years. And when I prepared the paperwork for her to sign this morning, she said she's not agreeing to probation. She does not, at this stage, understand that deferred adjudication is a form of community supervision. And based upon that, she said she wanted a trial.
Oh, okay. All right. Well, that's fine.
That's a question. Is deferred adjudication also probation?
It's under the general terminology of probation.
Okay, then I'm
But-
okay, just waive the fine and then we can do the deferred adjudication.
I'll try again to do the paperwork, Judge.
Yeah, the difference between regular probation is you're found guilty, sentenced, then your sentence is suspended so long as you follow the terms and conditions of probation. In deferred or unadjudicated probation, there is no finding of guilt. But you're on similar conditions of supervision. The length of time is the same. You can be no less than 2, no more than 10 years confined term of probation. It's in the court's exclusive discretion under law. And in both regular and deferred probation in this county, we terminate probations early in a third if you've done well. So, you can do the math. Yeah. See,
Does that affect my license to practice?
I don't know.
Okay, just making.
There is enough, the record will reflect there is sufficient evidence supporting a finding of guilt. However, no finding will be made so long as the defendant follows the terms and conditions of probation. That rendering does make a difference in some environments, some issues that bothers whoever the licensing authority is. But all of those are all unique and different. I don't know how it applies. You're talking about the practice of law.
Yeah.
I don't know how it will apply,
Yeah.
really. But I do believe I know some lawyers who are currently on deferred or unadjudicated probation who are practicing law. Okay, so
I'll
y'all are
work on
something.
trying to get the paperwork for him. That's not working.
All right. Katrina Davis, are we ready on Ms. Davis's case? Okay. We're working on the hard copies. Kind of like in the old days here, and then this will be scanned in to the records. 2835837 is now called the state of Texas versus Katrina Davis. The defendant is present. You are going to represent yourself.
Yes, sir.
All right. And the state's attorney is present. Now, for the record, set forth your experience and training in law, that and you are an attorney at law here, and you're licensed in the state of Texas.
Yes, I am.
And if you would be so kind to just give a summary of your experience with law.
I do business law.
Ma'am.
I handle business law. I am an instructor for the state bar. I am on for business law. I am one of the panelists for 2020, so qualified to be able to discuss business law in regards to the annual meeting, the 11th one. I have practiced for the last 7 years and have clients both civil and have handled criminal cases with Brennan Dunn, have handled criminal cases with Brennan Dunn as one of his assistants, I guess.
What have you done in those? Have you handled felonies as well as misdemeanors?
He did do a felony
Okay.
case, yes.
Numerous?
No,
Okay.
I did one with him only.
Okay. Was that a trial?
It was.
Okay, so you sat in the trial and went
Yes.
through the trial?
Yes.
Any, anything else to add as to your experience and training under law?
No,
All right, or do you understand, you certainly have a right for your own attorney if you wish.
yes,
Are you willing and exercising your right to represent yourself pro se? Are you doing that voluntarily, knowingly, intelligently? And is that what you insist on doing here?
yes.
Go ahead.
I thought we had did that already.
We're putting it on the record during the plea hearing so that
Okay.
we know as you're about to enter the plea hearing, you haven't changed your mind on anything you may have said in the past.
No,
This is what you insist on doing,
yes.
representing yourself.
Representing myself in the matter, correct. I had an attorney. Some of the items that he mentioned that I supposedly have received, discoverable items or not, something that I received, so from the attorney. But yes,
Are you ready to proceed today, though?
we are doing the deferred adjudication.
No, are you ready to proceed
I
today?
am ready to proceed.
Okay.
If needed to this.
Do you waive a formal reading of this indictment that was handed up under 20-35837, handed up on November 4th, 2020 by the Jefferson County grand jury? Can we proceed in summary?
I don't waive it this time because there was an error on the indictment.
What?
You said that there was an error with it. It was the language of the document. And you said it was a valuable error. And I thought, when I took the bar, that that was one of the things that had to be.
You're gonna have to refresh my memory here.
I believe the references to the second from the bottom line. And I thought that I made a oral amendment to change the word us at the end of that to is. That's what my notes reflect, although I didn't date it. So if not, I'd like to orally amend to change that word to, from us.
Ma'am?
I would like to object to an oral amendment. I thought when the indictment is done.
No.
according
When
to-
if it's an obvious clerical error, that's changeable. You know, it doesn't make any sense the way it reads. And it can only be intelligently reasoned as the word is capable of causing versus was, since that's the wording in the penal code. But it's I mean, it's obvious it's a clerical error, which is fixable. You understand?
I understand that you said it is fixable, absolutely.
All right, then, I mean, and there is absolutely no surprise to you what this intends to say, correct?
What it intends to say, can you please read what it is intended to say?
Is versus us.
Okay, then yes.
Okay. Anything else? The court is going to the court can make corrections on when it's obviously a typographical error. And the court finds there is no fundamental error here. Also, there is no surprise to the defendant, and the defendant has entered into a plea agreement with the state to plead to the indictment under a deferred or unadjudicated probation agreement. All right. The word us in the second line from the bottom in the phrase that in the manner of its use and intended use, us capable of causing serious bodily injury and death is changed, us being US, that spelled US, that phrase is corrected because it is an obvious typographical error intended to be that in the manner of its use and intended use is capable of causing serious bodily injury and death. which is the wording of the definition of a deadly weapon under the penal code. So that is corrected. And the court finds there is no surprise here, and the defendant has agreed to this. In summary, and do you agree we can proceed in summary?
Yes,
In summary, this indictment alleges that on or about September 24th, 2020, in Jefferson County, Texas, you committed the first-degree felony of aggravated assault on a public servant. Do you understand what is alleged here, ma'am?
yes, that I committed, allegedly committed, I guess.
Aggravated assault on a public servant, as it is alleged in this indictment.
Absolutely.
If convicted, this is a first-degree felony, which means you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, Your Honor.
An agreement has been reached where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length. The court decides that there is no fine here. Is there any restitution?
No, Your Honor.
There is no restitution. So the normal and customary terms for this type of offense under probation would be carried into play and would be part of the order of probation. Is that your understanding?
I object to pleading guilty.
I'm sorry, what you said?
I object to pleading guilty. Is there no contest available under the deferred?
That wasn't my offer, Judge. And she's already signed the admonishment.
Okay, well, you can't just surprise us here. I mean, that was, you don't drop that sort of thing on everybody. I guess you can insist on pleading no contest, but what does the state say? This is supposed to be a plea agreement between the parties. Are you saying that
May I see
It's
the
not you.
admonishment, Judge? I don't, at this
You
stage, Judge,
you could probably plead no contest unagreed?
I don't mind if she pleads no contest with the signature that she's got there. I just need to get the court some additional information based on it. If I can have a moment while you proceed, I'll get it.
Tim, she signed the judicial confession on that.
We're good to go, Your Honor. Chief says I'm good.
Okay, how do you plead to this? Guilty or not guilty or no contest? Okay, do you understand a plea of no contest or nolo contendere
Yes.
in Latin? Has the same effect, a knowing and intelligently made plea of no contest, has the same effect as a plea of guilty, although it may not be used as an admission of liability in any civil cases. Do you understand?
Yes,
I'm going to show you what's marked as State's Exhibit 1. Did you sign that document voluntarily, knowingly, and intelligently? Did you understand its contents? And is everything true and correct there?
everything is true and correct, and I did knowingly and intelligently sign the stipulation waivers and judicial admissions.
No.
And then the, if found guilty, if convicted, first degree felony, 5 to 10 years. I seen there was a signature on the side, so I didn't know if that was.
Okay.
Initials.
State's Exhibit 1 is tendered into evidence. Any objection? No objection. Without objection, it's admitted. You need to sign down here too. And this right here. It says counsel for defendant, but That needs to be signed. That's a waiver of all appeal.
Okay, so I'm signing as counsel for myself, right?
Yes, ma'am. In fact, instead of, why don't you mark through counsel for, and then it will just have defendant, and then.
Since she's doing that, Judge, she's already signed here. Do we want to then take that off?
Yeah. Yeah, that's not necessary.
Okay. Just as one line there.
And here on this. Agreed punishment recommendation, I'm gonna walk through this. Well, you've signed that. I'm gonna just put NA. Oh, no, I'm just gonna put pro se in on that, okay, since you've already signed. States Exhibit 1 admitted without objection. Among other things, this states that you are mentally competent to enter your guilty plea, which is freely and voluntarily made.
Yes,
You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with your method of representing yourself pro se in these proceedings. You understand you have a right to have your own independent attorney as legal counsel. You are waiving that and making that decision voluntarily, knowingly, intelligently. All of this, it states, is true, so help you God. Is that so?
I thought that it was not guilt until after, I think the admission of guilt is not found until after the further adjudication.
No, there isn't, no. There is enough evidence here from this admission here to find you guilty beyond a reasonable doubt.
Okay,
But I am deferring any finding of guilt so long as you follow the terms and conditions of probation.
which is, whatever.
You're gonna go in front of the probation office, you read those.
Oh, wait,
Like
never
go-
mind. I'm confused. I don't want to do, there's no probation. I don't want to do probation, not community supervision.
See, this is
That's
the
fine, I'm
problem.
sorry.
This is the problem here when you represent yourself and you say what you know what you're
Oh,
doing.
they're changing.
This is, no, ma'am. Deferred or unadjudicated probation is a form of probation. Probation is a generic term. We use that generically in the practice of law. It is community supervision formally, but is also referred to as probation, whether it's regular probation, which is where you're found guilty and your sentence of imprisonment or confinement is suspended so long as you follow the terms and conditions of probation, or deferred or unadjudicated probation, where there is no finding of guilt so long as you follow the terms and conditions of probation.
Okay,
See, that's another problem we have here when you elect to represent yourself in
why don't
a
we
matter of law that you're not really familiar with, which you can do. And from time to time, individuals do that, but generally they're not as trained in law as you are.
Absolutely, Your Honor. I just wanted to figure out what the terms were before I agree.
There
to
they
it.
are. They're normal and customary in all cases.
10 hours of community service restitution.
Not to, no,
I'm sorry,
it's not.
anger management. I'm not 17. This was just given to me, so that's why I'm not sure. And I don't think that's customary in every case.
Ma'am, when you're on
Anger
probation, you don't dictate the terms of your probation, the court does.
So I don't agree to those terms.
Then this is withdrawn. We will set this for trial. Thank you. That is all.
Mr. Laird is willing
Huh?
to try, Mr. Laird's willing to try that case for me.
Today?
Yes,
Okay.
both him and.
All right. Have a seat.
Mr. Duchamp.
All right. Who else is? Yes, buddy. Brenda.
Roderick James.
No, man, we're moving forward today.
Yeah, there is no plea.
All right, back on Miss Davis.
Yes,
Yes, sir.
We recall 235837 Katrina Davis. And the defendant is insisting on electing to represent herself. She is a licensed attorney. She certainly would be competent to make her own decision. She's intelligent enough. Anybody to pass the bar exam's gotta have a lot on the ball, and it has a level of intelligence and understanding of law that most novices do not have. And she has elected to represent herself. There is a document here called Election to Self-Represent, which states that I have been advised on October 2nd, 2023 in the criminal district court of my right of representation by counsel in the case pending against me. There's only one case, right?
Yes.
We'll change that later. Put in parenthesis the S.
Yes.
Okay. I've been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I am not financially able to employ counsel, I wish to waive that right and request the court proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. I understand that I may withdraw a waiver of the right to counsel at any time. I am making this decision freely and voluntarily. If you'd be so kind to sign, thank you. And this is for the record for all purposes. And again, do you waive a formal reading of this indictment? Can we proceed in summary once again?
Yes.
In summary, this indictment alleges that on or about September 24th, 2020, in Jefferson County, Texas, you committed the first-degree felony of aggravated assault on a public servant, which carries with it a term, if convicted, of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand what you were charged with and the punishment range applicable?
Yes.
An agreement has been reached where you would not be found guilty, but placed on deferred or unadjudicated probation, which can be up to 10 years in length, no fine. There will be terms and conditions of probation, which will be prepared. The court will approve. These are normal and customary for this type of offense. Do you understand?
Yes.
If I follow this agreement, you will have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this offense charging you with the first-degree felony of aggravated assault on a public servant? Guilty, not guilty, or nolo contendere, no contest?
No contest.
Are you pleading no contest voluntarily, knowingly, intelligently? And do you understand the consequences of pleading no contest, which is a plea of no contest? Has the same effect as a plea of guilty, except it generally cannot be used in any civil actions brought forth from the facts of this case that you were pleading no contest to.
Yes.
So there's no plea guilty here on this, because I think it's been neutralized before, and we took out so that it would work both ways for no contest. And how do you plead no contest to this charge?
Yes,
I show you what's marked as State's Exhibit 1. Yes, did you sign that document voluntarily? Did you understand it, discuss it with your attorney? Are the contents all true and correct?
yes,
State's Exhibit 1 tendered into evidence and without objection, it is admitted. Stand down. Among other things, this states that you are mentally competent to enter your plea, which is freely and voluntarily made. You understand what you are charged with. The indictment's been read to you, or you read it. You are guilty of the crime charged in any lesser included offenses. You are getting through your plea of no contest. You are giving up your rights of jury trial and the right of the appearance, confrontation, cross-examination. You were totally satisfied with the representation provided by yourself in this case, since you were self-represented. And you swear all of this is true, so help you God.
yes,
State's Exhibit 1 is made a part of the record for all purposes. Because this is no contest, the state has an opportunity to read into the record any additional evidence which supports the defendant's no contest plea, so that there is enough evidence presented for the court to find the defendant guilty and then defer those proceedings under this agreement. And you can but this is going to have to be later sworn to right here.
yes.
You can proffer the information.
Just a second. Judge.
There has to be an independent presentation. I don't, unless you want to throw in the
According to
probable
the-
cause affidavit.
I'm going to tender the information from the probable cause affidavit provided by Officer Trey Armstrong with Beaumont Police Department.
Okay,
All
a
is-
copy of that can be made a part of the record. Is there any objection to it, ma'am?
I'm sorry, the police officer.
Yes.
I thought he was the fire marshal.
Well, whoever the person is who prepared, I'm presuming it was
The
an
victim was,
officer of some sort, but anyway, here, this is it. Have you seen that? He's gonna put that into evidence from the state's presentation, then you can make any objections or changes to it.
Object to a no.
Hmm?
I object to the wording of the statement denied. After swinging of the knife.
Is that it? Is that all?
Yes, sir.
Okay, the rest of it. Without objection, except for that portion dealing with the knife, then it is made a part of the record as state's exhibit sticker. Please. Problem is, you're gonna have to add something else on your own unilaterally, since that makes up an element of the offense, right? What it takes to make a first degree felony is the use of a deadly weapon. He's objecting to that portion of state's exhibit 1. She's pleaded no contest to this. There still has to be an independent presentation when there's not a plea of guilty. It's to support a no contest plea.
my position is that her objections are not lawful. She's given no grounds as to why she's objecting to those matters. This is a probable cause that has been a portion of the court's file. There's nothing more than a recitation of the facts as well as the admissions that she's already made that are contained within the indictment, as well as State's Exhibit 1, which is the judicial confession.
Admissions.
What essentially what he's saying is really, you don't have to agree this is correct, but it is his proffer from the state's presentation that that's what he his evidence shows is true and correct in this. You can object, but otherwise that it's his presentation. This is what he is alleging. He is presenting as an independent presentation that his case would show, and you're objecting only to that portion dealing with a knife. Your objection is noted. It will be overruled. The State's Exhibit 1 is admitted, and your objection to the use or presentation of a knife is going to be shown in the record that you differ on that, but yet you are pleading no contest to the indictment, which includes as an element that a deadly weapon, namely a large knife, was used.
Your Honor, the proper addition is that there is a civilian witness by the name of Tasha Coleman who is on standby for the testimony in this trial. Her specific statement, as well as testimony that she would provide in trial, verifies that this individual began to swing a knife at the fire marshal, which is Terrence Simon. I'm quoting directly from her report. The state has that physical evidence in and would present it in trial. Officer Simon is available as well to testify about the knife that she is swung at him. The officers that responded are and additionally would testify in trial are officers Armstrong, Price, Roberts, Gilmore, and Leslie that all had dealings with her that day that also affirm those accusations that are subject to this conversation.
Okay.
I object again to Tasha's statement.
Yeah, just fine.
So
You are allowed to introduce other documentation if you want to do that, to support that. That just. Are you objecting, or are you going to just not? Or are you intending, because I know your goal is to get the end accomplished, which is placing you on deferred or unadjudicated probation. But this step is, we're stumbling on this step. Are you insisting on objecting, or are you just going to stand mute? Once again,
I am
otherwise he'll be entitled to present more evidence into the record, and that may or may not be what
Tendering that statement.
you feel is in your best interest in the end game of what you were trying to complete here. Because each element of the offense that constitutes the offense, there has to be some evidence to support it under a no contest plea.
So the statement that I saw, this wasn't in the record. This was in the record. So I will refer to the additional second page. The one page was the only thing that was in the record.
Yes, ma'am. Go ahead.
So let me look real fast.
Yes, ma'am.
What's the number we're at, Judge?
I'm sorry.
What exhibit number are we at?
I've got Court's Exhibit 1, which is the election to self-represent, and that's been admitted. You've got State's Exhibit 1 is the only thing I have. Then we also have here, well, there's two State's Exhibits. One, this is going to be number 2. State's Exhibit 1 was part of the plea papers. We're going to call this
Let's make
State's
that
Exhibit
3.
You want this 3?
Yes, sir, because State's Exhibit 1 is the judicial admission. The court's admonishment as to
Is courts, it's
Court's
courts 1.
So we've got states one should be the admonishment within the plea.
Or states two.
Let's make that states three, which you have in your hand.
Okay.
This will make this
Three
states two.
is what's already been
She
introduced and admitted as states one. We have corrected that to states three because states one is part of the plea papers that are already in evidence. So where's your state's exhibit two?
States two is being
Tender,
reviewed
yeah.
by the defendant. It is a statement from Natasha Coleman.
Natasha Coleman identifies it as a spatula, not a knife. It's a spatula that she mentions. I still, object to the swinging. I object. She says spatula again. Let's see. If it was louder, she would have- And I charged at her, I object to that. At no point did she say on the 911 call that I charged her. She said there were other people in the facility that possibly could have gotten charged with anything. I was walking around. That's when we saw, late outside, when we saw a fire marshal truck pull up. That's when I asked him if I can get the police here sooner. We went back to his truck to make a call. And they came back inside the store and I approached her. She began to swing the spatula at the fire. She wasn't there. There was no female standing there with me when I spoke to him. So I object to her statement, page 2. I object to the fact of I really agree to the spatula that she mentions in her statement.
That still doesn't make the element of the offense, which is a deadly weapon was used, which she's pleading no contest to. The state's exhibit 2 is also introduced into evidence, but it's objected to by the defense in her version of the facts.
And the state's position is those are not legal objections. Those are her saying that something happened differently in an attempt to try to testify to the court.
I understand.
This-
I understand your
Yes, Your Honor.
objection. They're admitted
Thank you.
under the method of this plea. She's pleaded no contest and understands what that means under the law, and that the elements have been supported by not only her plea, but states 2 and 3, which is the states. Which are 2 and 3, which are reports that the state contends support the indictment in this case. Anything else by anybody? If not, I'm going to make the following findings: that the defendant has pleaded no contest and understands and it's pleaded voluntarily, knowingly, intelligently, understands what that means, that it is not admitting guilt, but with independent evidence under states exhibit 1, 2, and 3 to support the no contest plea. That is enough to find the defendant guilty beyond a reasonable doubt. It is not usable, though, under any civil matters which may be brought about pursuant to the underlying facts and allegations of this case, but it does support the elements of the crime to find the defendant guilty beyond a reasonable doubt. However, I'm going to follow this plea agreement and defer any finding of guilt and place the defendant on deferred or unadjudicated probation. Again, here are the deferred or adjudication orders, which are normal and customary for this type of offense. And this is for a term of 10 years. you do well, it is shortened in 1/3.
Yeah.
And I dismiss cases, deferred adjudication orders are not terminated like regular probation, they are dismissed. That's how they end, with a dismissal of the case. I do that literally every day. 85% of our cases are either terminated or dismissed. Most of our probation are deferred or unadjudicated, a large portion of them. And you will. I've signed these orders. Please see the probation officer. You will review them. Once you sign, you will begin this, and the quicker it begins, the quicker it's sent. Do you understand what has happened today, Ms. Davis?
Yes, just one quick question. Post-sentence investigation fee of $500. Is that after everything's done?
I don't need that. We're gonna pass on that one. Because I think I've got, generally, I don't have the kind of information I've been given in this case. In most of these cases. And what that does is that fee goes out to determine any conditions, any additional conditions of probation that are necessary. And our goal is to assess conditions of probation, which can ensure our high rate of success of probation. Okay, so that is all.
We're not conducting one at all.
No, it's not necessary in this case. I think the court has enough to understand, and the element, the conditions that we've added in there, I think will be enough to have a successful end in this deferred or unadjudicated probation.
What about the inside the home every day between 10 and 6 a.m., 10 p.m. and 6 a.m.?
These are normal conditions, Your Honor. It's your probation. If you want to change it, you can.
She needs to make a living.
Well, it's except for employment purposes. So that was a work exception to the curfew. So it shouldn't impact her job.
Well. What's they say to that on this case?
As long as she provides proof that she needs to be working during that hour, I have no problems with it being exempted. I don't want to deviate from the standard rules, right? And as I understand them, that condition is this department always allows people outside of those curfew for work purposes. So she just needs to be required to give that proof to the probation
What's the
department.
curfew? 10-6?
10 p.m. to 6 a.m. This one.
I don't know any lawyer that's practicing law between 10 p.m. and 6 a.m. unless they're at their office working overtime.
I'm trying to understand the part about being a licensed attorney in the state and having never done anything in the past, have no criminal record, having to now not be able to go out after 10 p.m. I mean, I think it's a red flag to say, you know, I'm also with the state bar. I am an instructor. I am on the planning committee in Austin. So I think that it wouldn't, you know.
All of those needs will be exceptions to the rule of you having to be in, like I generally am, from 10 to 6.
Married.
I'm married too.
You guys don't go out at night, so that would be my only objection to this. I saw anger management and I saw the 10, and then also I do have a question in regards to complete job search as directed.
Yeah, you have it. That's for people who don't have a job.
Okay, and then be inside the home every day between 10 p.m. for 10 years.
You're not going to be, you won't be under the supervision for 10 years. I'm pretty certain. Now, it is a problem for 3 years. Yeah.
Okay, well, I will.
Hold on for just a second. For a little over 3 years. But here's what happens. Here's what happens, ma'am, every day. I get calls or sent emails asking for exceptions by people who have personal matters that they need to take care of. And I approve them in every, my question, the only question I ask for the probation office is, are they fine and are they doing well on their terms of probation? And you make a request. If you're doing well on probation, generally it's approved. And these are all personal requests. It has nothing to do with work. And I approve them as long as it's,
Submitting a literacy testing, I mean, I'm.
you're gonna,
really nice.
that's to ensure that the people do understand and know the terms of probation. But most of those are not gonna be, they're not gonna waste their time on people who obviously are illiterate.
You do not leave Jefferson County without permission of the community supervision. I don't live here. I live in Harris.
Harris County is where it's your home county.
So initially Harris County.
She's writing on the
Not
document.
change my order. I will.
This is your order. I thought it was your document.
That's the judge's.
I've signed that.
Oh,
Don't,
shit.
yeah, don't write on it.
Sorry
write
about
on it.
that.
But it's home, it's your home county, not Jefferson. It's just printed in there. They change it. They just can't do it that quickly, but they'll change it to adapt to your personal needs.
Wait
Yeah.
a minute then.
Yeah, it's Harris County.
It's Harris County.
Yes,
So
ma'am.
can we have that on the document so that they,
That's gonna be changed.
During the intake. So this is not the intake. This is just an instruction on where to go as soon as you leave here. And you'll communicate this information to the officer that you speak to during the intake. And they'll.
Yeah,
assess
because we
those
have
needs
5,000
and communicate
probationers.
Those changes. as
We-
needed.
It's
So they'll-
it's generally a Xerox copy that then gets changed as you are being processed into the probation system.
and this is for everyone that comes. to the
Everybody.
Board of Adjudication.
And nothing but everybody, so help me God.
Okay, so let me look and see. So I go here, close from noon to 1. And.
Here, why don't you work with her, work with him out there? I've got these other people I've got to get done. Mr. Patterson, Zarin, come on, let's take care. Here, give it to him.
Okay.
All right, let's take this back. Go ahead.
It's for Harris County, that's down here.
So she's made an alteration to this copy. And we just, it's
I don't live here, my mom's in Harris.
the proper way to affect that would be. When her courtesy supervision is established in Harris County. Is that, you want me to make that, are you wanting me to make that change, Judge?
Yeah.
Okay.
Okay, what else? Is that it?
Is it-
Yeah, just for Harris.
Yeah, yeah, it's always their home counties when we're not. When there's not a question about whether they really live there. We can go cut through the red tape and get to that. Okay, thank you. That is all on that one.
So I also need to-